Bismillahirrahmanirrahim. Aku nikahkan di kau Muhammad Azam bin Sharif dengan Cik Norina binti Long, berwalikan wali hakim dengan mas kahwin yang tersebut.
Aku terima nikahnya Cik Norina Long dengan mas kahwin yang tersebut.
Saksi? Sah? Sah. Sah tu kali. Alhamdulillah. As you two aware that this marriage is done outside of your home country, which is Malaysia, so you have to get recognition for this marriage and have to apply to the court and give all the evidence that you have been married here to the court where you domicile. Okay, you understand?
So that is all I need to do. Alright, thank you, Tok Eddie.
To successfully register your marriage, you must bring the official letter or official certificate issued by the Majlis Agama Islam in Songkla to prove that your wedding and your solemnization is legit. So, where's your official certificate right now?
They are not with us right now.
The court will not be able to verify without the official certificate of marriage issued by the by Majlis Agama Islam Songkla. So you must get the official certificate of marriage from authorities where you solemnize and get it, bring it on court on 25th September. Court is adjourned. The court is unsatisfied with the documents prepared by both parties, and because the document is doubtful to the court, and the court wants both of the parties to bring two witnesses that witness your solemnization at the time where the akad took place and obtain the official certificate by that were issued by Majlis Agama Islam Songkla. Court is adjourned. Where is the second plaintiff?
The second plaintiff and his lawyer is absent, but I have prepared all the evidence for our marriage.
Despite the absence of Muhammad Azam bin Sharif, which is the second plaintiff in this case, and also his lawyer, the court is satisfied with the evidences put forward given by the first plaintiff, and also the court is satisfied with the statement given by two witnesses that who come to this court and give statement. The court also found that the plaintiff had successfully proven that the marriage was in accordance with hukum syara and also according to local law, which is enactment Undang-Undang Keluarga Negeri Pulau Pinang. Therefore, the court believes that the marriage between the first plaintiff and the second plaintiff is legal according to hukum syara.
Assalamualaikum, it's a Syari'i lawyer. I want to tell you about why the appellant want to appeal the case. So the appellant want to appeal the case to the court so that the court will overturn the previous decision that have been made by the previous court. So since there are some flaws and also incomplete in the evidence that have been given by the respondent. So first of all, the problem that we have in the evidence from the respondent is the respondent did not give the original certificate of a marriage, but she only gave the photocopies of it. Second, the appellant claimed that he was forced to get into the marriage, and about the mahar, there are a dispute regarding to the amount of the mahar. And lastly, the court did not take the statement of the wali in delivering the decision. So because of that problems, the appellant believed that he need to appeal the case since there are problems in the evidence from the respondent. Thank you.
Thank you, Counsel Muhammad Anwar. For the first claim made by the appellant and his counsel, the court found that there is no problem with a copy of marriage certification put forward given by the respondent, because even though it is a photocopy of it, it is verified through the statement by both witnesses that give statement to the court. According to Section 47 of Enactment Keterangan Syariah Pulau Pinang, proving a fact can also be done by verbal statement and also by providing documents. In this case, the court had taken the statement of both the witnesses of this marriage and also the documents provided by the respondent. For the second claim made by the appellant and his counsel, which is he claimed that he was forced to get into this marriage, the court found that the appellant is unable to prove this claim, and hence because the party is unable to prove his own claim, then the court found that the claim made appeared to be not true. The court will also dismissing the rest of the claims made by the appellant because the respondent had successfully proven that the marriage is lawful and also it satisfies the 5 pillars of marriage that hukum syara needs. Bride in this case is the respondent, the appellant is the bridegroom in this case, and the akad was verified by 2 witnesses that gave statement to this court, and the wali in this marriage is wali hakim, and according to hukum syara, wali hakim will have authority to a marriage if the distance between the wali and the wali hakim and the wali gaib is 90 kilometers or 2 marhalas away. In this case, the distance requirement was satisfied, and hence the wali hakim is legal, and this marriage can also be registered under Section 40 of Enactment Undang-Undang Keluarga Islam Pulau Pinang because it satisfies all needs that was needed by the hukum syara. The court dismissed the claim by the appellant and retaining the decision of the previous court. Court is adjourned. Case is dismissed.
In this case, the marriage is still valid because it fulfills all the pillars of marriage, which consists of Sirah, which is Ijab and Kabul, bride, groom and wali, and 2 witnesses. This means the marriage is valid in hukum syara. Other than that, from legal perception, to determine whether the marriage is valid or not, it is the power of the court to determine the validity of the marriage, as stated in Section 48 of Administration of Islamic Religions of Pulau Pinang No. 6, 1993. Next, as stated in Section 11 of Islamic Family Law No. 2, 1985 enactment, which this section stated about the validity of one marriage which have to follow the hukum syara. Even though the marriage is made outside the Malaysia, it is still valid as stated in Section 108, Clause 1 in the same enactment. The appellant failed to prove any of the arguments made by him even though he stated that the marriage was not valid.